Okay, welcome everyone to the Michigan Indian Legal Services presentation on estate planning. My name is Norika Kita Betty, and I'm one of the staff attorneys at Michigan Indian Legal Services. I will be moderating today's presentation along with our pro bono and communications coordinator, Hank Fields. Our presenters today are MILS attorney Ian Tulloch and MILS pro bono attorney Diane Kuhn Huff. Currently, Ian serves as the MILS estate planning attorney under a grant through the Administration for Native Americans, or ANA. And Ian will talk more about his program during today's presentation. Diane is a partner with the law firm Anderson and Huff PLC in Traverse City. She has over 20 years of experience with estate planning, probate administration, and elder law. And Diane is a certified elder law attorney with the National Elder Law Foundation and a Michigan super lawyer in the area of elder law as well. Before I turn it over to our presenters, I'd like to let everyone know that if you have a general question during the presentation, you can go ahead and type that into the comments on the Facebook page. And at the end of the presentation, if we have time, we'll try to answer as many of those questions as possible. If you already submitted a question when you registered, the presenters have tried to incorporate those answers into their presentation. As a reminder, the information that's being presented today is not legal advice related to your specific situation. It's intended as general legal information. It will hopefully give you a good overview and introduction to estate planning. This presentation is being recorded, so if you want to go back and watch it again, or if someone else you know would be interested, there will be a recording posted on the MILS Facebook page as well as the website. Finally, at the end of the presentation, we ask that you complete a short survey to give us feedback on this presentation. We'll post the link to that survey on the Facebook page, and also if you pre-registered, we will email out the survey after the fact. We'll also email out presentation materials if you have pre-registered and given us your email address. So with that, thank you all for joining us today, and I will turn it over to Ian and Diane.
Thanks, Norika. All right, so today's presentation is about estate planning and you. Estate planning is a great way to protect your loved ones, and Diane will be here helping me today, walking us through this presentation. Our talk today is going to cover a variety of topics in the estate planning realm. First off, we're going to cover what an estate plan is and why you should need one. Then we're going to go into durable powers of attorney, medical powers of attorney, also known as patient advocate designations. We'll go into funeral representation agreements, beneficiary designations, ladybird deeds, which are known as enhanced life estates sometimes, as well as wills. Then we'll cover briefly trust and pour over wills. And lastly, we'll cover any questions that we have remaining. So to get started, what is estate planning? Estate planning is making a plan in advance. You name the people that you want to receive the things you own after you die. It's taking the steps to carry out a plan that protects you and your loved ones. And these plans can include instructions for your care and financial affairs if you become incapacitated before you die. So that would be covered by the power of attorney, the patient advocate designation. You can name a guardian for any minor children that are left behind. You can also provide for family members with special needs without disqualifying them from government benefits. This is known as a special needs trust. And what those trusts are used for is to help provide for a loved one's needs without getting in the way of either Medicaid or any other services they may be provided. There's also ways through estate planning to provide for a loved one that may be irresponsible with money, may have some issues with substance abuse, or may try to protect some assets from creditors. And there's different trusts that can be used to do that. Some are called spendthrift trust. And what it does is it keeps creditors from attaching to the principal of the trust. And also, estate planning is a great tool to minimize taxes, court cost, and unnecessary legal fees. But one of the most important things that estate planning does is it gives you peace of mind. It helps your loved ones know what your plans are. It minimizes fighting between family members, and it keeps things as simple as possible upon your passing. Do you have anything to add to that, Diane?
No, I think you covered it very well, Ian. So we'll just get into the meat of the program.
Okay. So when you're estate planning, there are a few things you should be concerned about. Like I stated before, providing for minors or special needs beneficiaries. Also, concern is avoiding lifetime probate and minimizing death probate. So lifetime probate would be a guardianship or conservatorship, and they're lengthy. They can get drug out in court, and they are not always in accordance with your wishes. But if you plan ahead of time using proper documentation, such as a durable power of attorney or patient advocate designation, we can avoid that lifetime probate. But the caveat is that has to be done while you still have capacity. And so on that point, another concern is just maintaining control of your affairs during incapacity so that there is someone to take care of your financial needs if you were to say be medically induced in a way to not be able to take care of that. So there's a stopgap in the background so that your bills can get paid, your mortgage, your taxes, all of those things. And also with proper estate planning, you can protect assets from long-term care costs. This is sometimes referred to as Medicaid planning. And one of the main tools for that is the Ladybird deed, which we will cover later in our presentation. And there are a few basic estate planning methods. The first one, and the one that I wouldn't recommend, is to do nothing. There are rules in place if you don't have a will in place. It's called intestate succession, and they're the default rules for how your estate is passed down. Next, there's will-based planning, and that is to divide out your assets using a will. Next is joint property and beneficiary designations, and those can be used to transfer property upon death, and they're great tools. There's also trust-based planning by drafting a revocable living trust or another kind of trust. You can help protect your assets, and use of powers of attorney. And a comprehensive estate plan uses different combinations of these methods so that we can protect the assets and protect your loved ones. So first, to get into it, let's talk about what happens if you do nothing. If you don't have an estate plan, there is going to be a process called intestate succession, which your loved one will open a probate for you, and your property will pass down due to these default rules that are provided for in EPIC, which is Michigan's probate code. And a probate judge will help decide the matters, and your wishes will not be considered. It passes by statutory rules, and there's not really any wiggle room. And like I said earlier, if you don't plan and you become incapacitated, there is going to have to be court proceedings to get a conservator or a guardian in place while you're incapacitated. And those matters are public record, they're in the courts, and it's often a lengthy, stressful, and expensive process that can be avoided with proper planning. And so those proceedings are called lifetime probate, and they last as long as the incapacitated person is alive and remains incapacitated. And lastly, the probate process after death usually takes a year to complete. It can be quicker, especially if there is a proper estate plan in place. Do you have anything to add to that, Diane?
Sure. So the quickest a probate can end is 5 months after it's opened, after the estate is opened and letters of authority are issued. So that's not a real long time. What often causes delays are disputes on the property, or property has to be sold, or and any other odd event happening with property to wait for. So a year is not unusual. Sometimes it lasts longer if property cannot sell. Sometimes it's shorter if things are fairly easily and it's pretty simple.
Thanks, Diane. All right. So next we are on to powers of attorney. And like I said before, your estate plan isn't only to protect your loved ones, it protects you during your lifetime as well. I'm going to talk about the patient advocate designation and the durable powers of attorney. So I'll get started with the patient advocate designation. This is sometimes referred to as medical power of attorney. And in this document, you designate the person who will make decisions for you when you're unable to do so yourself in relation to medical treatment and care. And in the durable power, or in the medical power of attorney, you can tailor those powers specifically to what your wishes are. So you can give the power to your patient advocate to consent to or refuse medical treatment. You can set the scope of care to, if you're incapacitated, you can lay an outline for under which circumstances you want life-sustaining care, or in which cases you want care withheld, whether that's an irreversible coma, whether it's care no matter what, or a spectrum in between. But they also have the power to arrange for mental health treatment, home health care, admit you to a hospital and nursing home, and they can authorize organ donations. And this is a more comprehensive way than, say, being an organ donor on your Michigan driver's license would be. And this document, it can pair with a living will and a DNR. So it's sometimes useful to have a living will with the patient advocate designation, just because the patient advocate may not be readily available. So it's something for that the doctors and medical staff can rely on. And so for these medical powers of attorney, there's a few conditions that must be met for that to be valid. So it has to be signed by yourself as well as 2 witnesses, and your patient advocate also must accept this delegation. And so the witnesses, they have to be over 18. They can't be the staff at the care facility, whether it's a hospital or a nursing home where you reside. And also, the witness can't be someone who would be an heir to your estate. So with that being said, we're going to move on to powers of attorney. And powers of attorney is a term that sometimes confuses people. What a power of attorney really does is it gives someone the authority to act as your agent. So they will act in your best interest for you, and they can act as you in certain ways. That can be broad or narrow, depending on how you draft the document and what your wishes are. So they can sign checks for you, make deposits, pay bills. They can sell your property, get insurance for you. Basically, they can do the things to manage your day-to-day affairs for you in the event of your incapacity. And there's also different ways the power of attorney can be used. So in estate planning, we use a durable power of attorney, which means it is valid even through your incapacity. So some people, they like to authorize that power immediately. Others want it to be enacted upon finding of incapacity. And so with these powers, it's helpful to avoid a conservatorship. And so your agent has to sign an acknowledgement of these responsibilities before exercising any authority. And the law has set forth the language that's necessary for that acknowledgement. But that being said, a power of attorney gives away a lot of powers. And so there may be instances in which you feel uncomfortable with the way that your agent is acting, or you just don't feel comfortable designating those powers to someone. So you can revoke your durable power of attorney when you are competent, but you must sign a written document that says the durable power of attorney is revoked. In that power of attorney, you can name multiple agents. They can either act at the same time, they can act separately, or as one person. And you can also name a successor agent. And a successor agent is someone who would step into the role if your first person that you designated was unwilling or unavailable to do so. Your agent has what's known as a fiduciary duty to you. They have to act in your best interest. They're not able to use that power to benefit themselves. They can't self-deal, and they have a responsibility to you. They got to keep receipts and accurate records about your assets. You can order an accounting from them. You can ask them to report to you on certain intervals. And lastly, if worse comes to worse and an agent is abusing their authority, anyone interested in your welfare can ask the probate court to get involved, and they may either act by revoking the power of attorney or by taking further steps. Do you have anything to add to that, Diane?
Sure. A lot of people think if they give a power of attorney to someone, they lose all control, and that's not true. When you give power of attorney to someone, whoever is the principal, so when I give power of attorney to somebody at my spouse or my children, I'm in charge of my money, and I'm always in charge of my money. And my agent under my power of attorney is to act according to my wishes. And if they act against my wishes, then that's when you revoke it. That's when they're abusing their authority. So it's just a safety net, and it's a really important safety net. It's real important to avoid a conservatorship. And then again, in the healthcare power of attorney, it's real important to have those to avoid a guardianship. And they're very simple to do, and I really recommend them for everybody.
And Diane, can you touch on real quickly why avoiding a conservatorship and a guardianship is something we so strongly recommend?
Primarily because it has to go to court. So, and when it goes to court, the whole family's notified, spouses and children of whoever is someone is saying you're incapacitated. And then you need doctor statements saying the person is incapacitated. And then if the person, objects to having a guardian or conservator, it can be a contested hearing, and that's never comfortable to do for your family members to contest them. Also, what I find a big important reason to have these is, competency isn't always black and white. There's often a long gray zone, especially if someone has some cognitive decline or beginning of dementia. They're still competent, but they just need a little help now and then. So the power of attorney is really useful because you can help them. They feel like they're in control, but the agent under the power of attorney can do all the legwork and all the detail work to help prop them up, to keep them safe and in home and feel like they have full capacity to handle their business.
All right, awesome. Thank you, Diane. That was super helpful. So next we're on to funeral representative designations. And these designations are fairly new. They were first implemented by the state in the late I want to say in 2017 or 16. And what this does, what this is part of was a larger overhaul of the priority for who would make these decisions upon your passing. And so what a funeral representative does is it elects who has the authority to make decisions regarding your final arrangement and resting place after death. Before, the laws were very unclear, and it led to conflicts as to who had that priority. But when they overhauled that whole section, they also implemented the funeral representative designation. And so it allows for someone over 18, other than your spouse or child or a close relative, to have the legal authority to make decisions on your behalf. And so your funeral representative has the second highest priority of anyone. The first priority would be the only person that ranks higher would be someone designated for you by the military if you were in active service under certain conditions. But your funeral representative will have the highest designation for a normal civilian, and you can choose pretty much anyone to be your funeral representative, except a licensed health professional that you're working with, an employee or volunteer of a veterans facility, someone that's working at the funeral home that will provide services for you. Similarly, with a cemetery or a crematory, or lastly, the person charged with your intentional murder is unable to act as your funeral representative. And just like the last documents we outlined, there are steps for a successor funeral representative if the first person is unable or unwilling to act. And if the person with the highest priority can't be found, or they're not doing their duties within 2 days of your death, the person with the next highest priority will fill this role. And the funeral rep designation, it can be a standalone document. It can be put in your will or your trust, but I'd advise doing it as a standalone document for a couple of reasons. The first and the most notably important is that sometimes when these are put in a will or trust, the family won't get to those documents until it's too late and your services are all said and done, and lo and behold, you were cremated while you would have preferred to have an open casket ceremony. So we like to have that document done separately for that reason. And additionally, your last will and testament, as well as trust, they contain information about your last wishes, arrangement of gifts provided to family members, and the funeral home doesn't need that information. So if you want to keep that information close to you, it's best to just put your funeral wishes in their own standalone document. And so your funeral representative has certain duties. They have the right and power to make decisions about your funeral arrangement, handling, disposition, disinterment of the deceased body, and they can make decisions about cremation, the burial process. And so when we do these documents at Michigan Indian Legal Services, we like to use it as a way to get all your wishes, whether from how you would like your body to be handled to the ceremony you will have, as well as graveside markers, or however you would like to handle that process. And like the other documents, there is an acknowledgement that must be signed, and they must acknowledge their duties. This power is only effective upon the decedent's death, and the power to act can't be assigned to someone else by your representative. And so there is a couple caveats to the funeral representative. The most notable and why someone may not want to accept this duty is that the funeral representative is liable for ensuring payments of the cost related to the disposition of your body. Whether it's through insurance or another person, your state, or the funeral representative themselves. And so by having that responsibility, some people will choose not to step into that role. And again, the funeral representative designation is revoked as the same, in the same manner that you signed it. It will require either a notary or a written revocation. And in the case that you were divorced, it will automatically revoke this designation to your ex-spouse if that's the person that was designated. And do you have anything to add on that section, Diane?
I'll just add 2 points of when I find the funeral representative designation is really important, is if you don't have next of kin that can make funeral decisions for you after you're gone, or they're pretty remote next of kin, and you don't want these people you don't know too well making your final arrangements, it's important to have a funeral representative designation. Or also if you have kind of a big family where they are designating, they have different opinions on how to handle your, what to do with your body, how to handle it, then it's important to have. I guess and one other point is if you have a prepaid funeral plan, then that's even better because your wishes are definitely stated. Thank you. That's it.
All right, thanks, Diane. All right, so the next thing that we are going to cover is beneficiary designations, and Diane is going to walk us through that.
All right, thank you, Ian. So beneficiary designations are when you just name a beneficiary in your death, and when you pass away, the beneficiary, that property goes right to the beneficiaries. There are some accounts that need beneficiary designations automatically. Things like life insurance, they need to have a beneficiary designated on it. IRAs or 401ks, any kind of retirement accounts, you want to name a beneficiary. Annuities often have beneficiaries. And then bank accounts and other accounts, security accounts, they now can have beneficiaries also, and those are called transfer on death designations. So they're very simple. It's just you name the people you want to receive that property, and they become the owner at your death. They might have to file a claim form, but that's not too cumbersome. It's quick. It doesn't. It can, as soon as they get the claim form in, it's automatic. It transfers at death right away. It avoids probate. The owner this is one of my favorite parts of it, is the owner keeps full control of the property and the account during your lifetime. So, some people like to add joint names on their accounts because they want to avoid probate, but by adding a name on an account, that person will become owner of that account and may have different views on what to do with the account. I prefer to keep my person full control of their property during their lifetime, and they can do that and just name beneficiary designations. Another benefit is, this is a pro and a con, which you can disinherit people by beneficiary designations. So if I have an account and I want it to go to my 3 kids, but I only put one of my child's name on it, then it only goes to one child, and I've inadvertently disinherited my other 2 children. For the same reason, it may be a good thing is I want it to go right to my children, and I don't want the property to go to my spouse. Then I can have it go right to my children and it bypasses my spouse. Another thing to think about when you have a beneficiary designation is if you have too many people on the beneficiary designation. If Ian's going to talk about ladybird deeds, that's when you don't want to have too many people on the deed as to receive that as a beneficiary. Most investment accounts, you can name several people on your beneficiary designation. It's not helpful. One thing is you really should keep good records of who your beneficiary is on those accounts, because some people forget they have beneficiary designations on the account, and then their family changes and it's not what they want anymore. So you have to be careful to make sure you have records of all your beneficiary designations and update them as needed. Another thing to be aware of is if you have any beneficiaries who have special needs or are minors, you might not want to name them as beneficiary designations. You want to name it a little more protection for those. So beneficiary designations are a little more cumbersome for minors and special needs children. Anyway, and the other thing about the beneficiary designation is that account or that property does not go by your will or by your trust. It goes directly to your beneficiaries. So you have to, that's why it's important to know who the beneficiaries are and whether you have beneficiaries on accounts. But other than that, it's a really good and simple way to transfer property at death. Thank you. Back to you.
Thanks, Diane. And just to add to that, these beneficiary designations, they can't be overridden by a will. So some people want to transfer property through their will, which they've already named a beneficiary for, and that is not going to be a viable estate planning tool. That will transfer according to the beneficiary designation and leave the intended devisee high and dry on that. And as Diane touched on earlier, ladybird deeds are a certain kind of beneficiary designation, essentially. They're known as an enhanced life estate, and there's been different stories about where the name ladybird came from. It was original. I've heard multiple attorneys say that it was used by Lyndon Baines Johnson to transfer property over to his wife, Lady Bird. But there's no historical backing for that. But it's a common story that's been going around. I guess it would be considered an attorney's urban legend. And what this does is it transfers a contingent ownership interest in the property to the beneficiary while retaining an enhanced life estate. And to put that in plain English, it means when you die, the person that you want to have the property, it will transfer to them automatically outside of probate. But you get to retain all your interest in the property. And the person that you designate to have, to be the recipient, they don't have any rights until your death. then it automatically vests. So during that time, you can use control, profit, sell the property. So it's essentially providing you with all the benefits of owning your property. You're not giving away any rights to the designated beneficiary. And so it's a useful tool because you can retain full control. As long as you're alive, it's yours to deal with. You minimize the probatable property. So your real property is not going through the court supervised probate process. It also prevents the property from being subject to gift tax, which may be enacted if you were to give the property to someone inter vivos or during your lifetime. Your property also may receive up a stepped up tax basis, which is useful because with the stepped up basis, you're avoiding a capital gains tax. So it's a way of avoiding taxes while transferring the property so that on their taxes, it doesn't appear as if they've gained a windfall. And in some situations, a ladybird deed can avoid an uncapping of the taxable rate on that transferred property. And one of the biggest advantages of the ladybird deed is that it's a useful tool for individuals anticipating the need for Medicaid assistance, and it may protect the assets from the Michigan Estate Recovery Law. As some people may know, Medicaid has very strict standards of what assets you can and cannot have while being eligible for the program. And if you try to offload those assets in certain ways, it can subject you to what's known as a look-back period, or basically a certain amount of time that you're ineligible. And also, there's the Michigan Estate Recovery Law. And that law is used to recoup expenses for someone's care. And so by using a ladybird deed, we have the tools to help try and avoid that. There are certain disadvantages to the ladybird deed though. One of the most notable is the way that it interacts with certain mortgage properties, depending on the bank and whether they count that as a transfer. And so a mortgage property sometimes has a prohibition on transfers, or if you're intending to remortgage the property or something along those lines, the banks may be unwilling to do so with someone that they consider to have an interest on the property, even though technically the person that you designate as your beneficiary has no vested interest until your passing. And on that note, do you have any other things to add, Diane?
Yes, on the ladybird deed, because a lot of people are asking about them now. I think they're great tools for small estates where really the biggest asset in the estate is just the house. And it's an easy way to avoid probate. There are some, another downside that when I look at ladybird deeds is, so the property is going to be owned at your death, it's owned by the beneficiaries immediately. And so the beneficiaries then have to come back together and figure out, well, what are we going to do with this house? If who's going to pay all the expenses until we figure out what we're going to do with it? And sometimes not all of the beneficiaries can do that. So, or are willing or will play fair. So if there are too many it can be a problem if there are too many beneficiaries on the ladybird deed. So if there are 5 children and all 5 children become owners under the ladybird deed, then they all have to get back together and figure out what to do with the house. And any one of them can really prevent the house from being sold or prevent from going forward. So it works much better when there's like 1 or 2 people on the ladybird deed. And then again, if that means you're disinheriting people, then maybe a ladybird deed isn't what you want. And I would recommend you really talk through those pros and cons with your attorney who's preparing your estate planning document and doing the ladybird deed for you. So there. As for Ian's mortgage question, I have heard recently that there are banks that won't mortgage a property when there's a ladybird deed on it. And so what ends up happening is the person who owns the property, you do another deed to have it conveyed all the way back to you without the ladybird language. And then after the mortgage is completed, then you do another ladybird deed. So it's fixable, but it's a little cumbersome.
Thanks, Diane.
Mhm.
All right, and now we're on to last wills and testaments. This is probably the most common estate planning tool that people think of when they think of estate planning. It's been featured in pop culture for as long as I can remember. And the ways that it's been representative are usually far from the truth. You'll see the reading of the will or a video will. Neither of those are actually a thing in Michigan, especially the video will. Those are not recognized in the state of Michigan and are not valid. And usually when we think of a will, we think of a will drafted by an attorney, but there are other ways of drafting the will. And in an emergency, some people have drafted their will by hand with all the material terms. And that is called a holographic will. Basically, it's signed and dated by the testator or the person making the will. And all the material terms are in their own handwriting. One of the cases that is covered during law school was a farmer who was pinned under his tractor, and he wrote his last will on the tractor while he was under there, and it was held to be a valid will. And so what the will does is it's a legal document that says who should have your property, who should care for your children after your death if there's minor children, and who you'd want to manage that property for the children. So you can name a guardian and conservator for the children in there. You can also put in there what's known as a testamentary trust. And basically it states like when the child is going to be to receive these items from the estate. And there is, like I said, the will can take many forms. And there's several requirements that a will has to meet to be considered valid. Firstly, you have to be someone who's eligible to make a will. So you have to be at least of 18 years of age and of sound mind and have the sufficient mental capacity. Also, it can't be done under duress. So when we talk about sufficient mental capacity, basically the testator should have an idea of the bounds of his property. So like what's in his estate. It doesn't have to be exact terms. I mean, some people keep a better watch than others. They have to know basically who their close family is. They have to know that this document is going to give their possessions away after their death. And they have to be able to actively participate in the process. And so when you draft your will, you're going to have to execute it. And ideally, you're going to have it signed. You're going to sign it in front of 2 witnesses and have it notarized so that it's a self-proving will. And when the execution is complete, we're going to want to keep that will safe. So you can put that in a fire safe. You can store a copy with the probate court, usually for a fee, or you can store it in a safety deposit box. But whatever you decide to do, make sure your family knows where it's kept, and give a copy to the person that you named as your personal representative. They don't have to have the original copy on them, but they should know that there is a will and where it's stored. And so a lot of people have concerns when drafting their will about their personal property. And so they want to give specific items to specific loved ones in their estate plan. And sometimes that can be cumbersome to do in the will, because if you put that in the will, you'll have to either revoke the will or implement codicils, which is an amendment to the will, revoking specific lines within the will. And so in Michigan, at least, you're able to use a personal property list. By using specific language in the will, you can have a separate list of personal property and who you want it to go to. And so there's a few legal requirements to do this. One is that it has to be tangible personal property. That can't be like cash or bank accounts or real property. It can't be intellectual property. And it has to be a written statement, or must be in the testator's writing or signed by them at the end. Ideally, both would be the best. It does not need to be witnessed or notarized. And the items that you are talking about in there, they have to be described with reasonable certainty. So using broad terms is just like tools may not be sufficient. But you can, like if you said automotive tools, that's probably good. And so the will has to refer to that document as one to be in existence at the time of the testator's death. And you can prepare this document either contemporaneously with the will, you can do it before, you can do it after drafting the will. And this list, it can be altered. And so if you're altering the list, just make sure that it's meeting the same requirements as your initial one, that it's signed, that's in your, ideally in your handwriting. And again, we want to make sure that our personal representative knows where to find this. And so when we talk about tangible property that this would pass on, this is something that can be ideally weighted, measured, felt, or touched. So think of like jewelry, art, collectible tools, and household items. It's not real estate. Real property cannot be passed down through this method. So that needs to be included. That needs to be transferred either via ladybird deed, via your will, or by a trust. Other assets that can't be included are money, promissory notes, title documents, securities, so that's stocks, bonds, options, intellectual property rights, so any trademarks or copyrights you may have, you can't transfer those through this list. And like Dan said earlier, items with beneficiary designations, these aren't items that can be transferred through this list. And so in your will, you can name your personal representative, and they are going to be the person that handles the estate. They're going to be the ones to open the probate for you and divvy out your property in accordance to your will. And so do you have anything to add on to last wills, Diane?
I just want to talk a little bit, just add a little bit on the personal property list. These lists are really valuable. They're really, really helpful for family heirlooms. And so if you want a certain, the basket grandma made to go to so-and-so, that's really helpful, because those are often things that people fight over. The ones that have a lot of emotional or family historical value. So it's very helpful to have that list.
Thank you. All right. So we are in the last section before questions, and this is going to be trust and pour over wills, and this is going to be covered by Diane.
All right. So I'm going to talk just a little bit about this so that we have some time for questions. A trust, think of a trust is like, I don't think there's any other screens. A trust, think of the trust as like a contract, and the contract is between me, the person who sets it up, and all my property is titled to my trustee. So I have an agreement between me and my trustee on how to manage my property. And while I'm alive, I want all my property managed for my benefit. And then after I'm gone, I want my trustee to take care of my property and distribute it to whoever I want, whoever I've named. So a lot of people use trusts as will substitutes. Trusts are very helpful for, the trusts are private. It doesn't go through what's in the trust does not go through probate. It does not have to be supervised by the court. And so it keeps things private and it keeps things within the family. With that said, sometimes you really want things to go through the court because the court makes the personal representative, cross the T's and dot their I's and do what they have to do to administer the estate. And with the trust, there really isn't any court oversight. So you have to have a good trustee who will handle things appropriately. Trusts are I highly recommend trusts for people, again, any beneficiary they have that is disabled, and especially if they receive some means tested government benefits. So a trust can help so that they don't lose their benefits. A trust can also help when there are children inheriting, and so you get to designate at what age they become, are they mature enough to handle the property? And then before that age, the trustee manages their property. And so that's I'm just kind of breezing over a trust a little bit, and that's a whole nother program. So when you have a trust, you also need a will, and we call it a pour over will, because in order for the trust to take care of the property in the trust, you have to title everything to the trust. So for example, my house wouldn't be owned by Diane Huff anymore. It would be owned by the trustee of the Diane Huff Trust. The same thing with all my accounts. They're all going to be titled to the trustee of my trust. And so sometimes, people acquire things that they don't title to their trust, or they forget about something, or and it's not titled to the trust. So that would have to, and there's no beneficiary, so that has to go through according to your will, and that would go through probate. So we have a will, so the only beneficiary of the will is your trust. So, and that's called a pour over will. Hopefully, if it's all done right and properly funded, there is nothing that goes by the will, and it's all governed by the trust. I know that's a really short overview, and if you have questions on it, please ask them and I'll elaborate. I'll elaborate further. So on that, and I guess I'd rather leave more time for questions.
Okay, awesome. Thank you, Diane. Before we get to questions, I just want to give a quick advertisement about my program. So as the A&A estate planning attorney, we are able to help draft simple estate plans for members in the tribal community who make up to 500% of the federal poverty level. So that means we are able to serve someone. And so if there's a household of one, we can serve someone who makes up to about $65,000 a year. And so this is a free service, and you can call us today or at any time to do an intake. And our number is 231-947-0122. And if you do an intake, we can talk about your state and what works best for you. With that being said, let's field some questions.
All right, it looks like we do have a few questions in the chat. Hank, are you able to ask some of those questions?
Sure. The first one, clarification. Is an estate plan in lieu of a will or in addition to?
So an estate plan is the combination of all these things. Basically, so a will is a part of an estate plan. A trust can be a part of an estate plan. Estate plan just means basically preparing for your incapacity and your eventual passing, and the way that your property and your and providing instructions for your loved ones. Does that clarify things?
Yes, yes, very good. The second question is, what is the protection of a power of attorney when you revoke it? How does an entity know the power of attorney is revoked and the paperwork is no longer valid? Example, if I gave my friend power of attorney 1 month, revoke it the next, what stops my friend from showing that the now invalidated paperwork the following month, the third month, from selling my property?
All right. Well, ideally, you want to notify anywhere that you have business, like your bank or insurance company, that that power has been revoked. But Diane, can you elaborate on this?
Sure. When you revoke a power of attorney, you want to send a copy of that revocation to the person that you're, whose authority you're revoking. Because then if they go out and try to use it, that's really stealing from you. So that would be a criminal act. So you want to notify the agents, but you'd also want to notify any account, any financial institution where you have an account that was revoked. And just in case that person who's not trustworthy anymore, or you just would try to use it. So they're all on notice. And I can't say it won't be abused, but again, that's your best remedy, is just taking proactive measures to let everyone know.
And again, that is why we emphasize choosing someone that you trust to be your power of attorney, because you are giving them a lot of authority. And there's steps that you can take to remove that authority and hold them liable, but there's certain damages that can be done in that time. So again, it's just ideal to choose someone that can be trusted so that hopefully that issue can be avoided altogether.
Okay. Would or could a funeral representative relieve your next of kin with identification of the remains if necessary?
Do you have an answer for that, Diane?
I don't have an answer to that. And because I think that I don't have an answer to that, but I suppose you could designate who you want if you know there's someone who could not do that to identify the remains. I don't think there's a specific law on that. Do you, Ian?
I've not dealt with any. I guess I've never dealt with the law of, identifying someone's remains. So that'd be something that we'd have to look into. But it's a very interesting question that I think deserves a deeper answer and some research on.
Okay. And are there conditions in the Ladybird deeds forcing a sale if one or any beneficiaries cannot afford the taxes, cost of maintaining the property? Or would they only be forced to sign off on the property?
So the Ladybird deed, it grants the parties the interest in the property. If you wanted to have subsequent conditions, I would say it'd be ideal to draft a trust in relation to that. Because a trust can cover multiple generations, as long as it falls within the rule of perpetuities, which is something that I'm not going to cover today because it takes tons of time to explain. But basically, within 2 generations, you're safe to vest property, and your lawyer can clarify that, but in the limited time that we have. But there can be those subsequent conditions. And so if it was to vest in a way that a condition was not met, there could be a certain action forced to the benefit of the next beneficiary. Diane, do you have anything to add to that?
Right. So if you have done a ladybird, you had a ladybird deed, and let's say there are 2 beneficiaries, and one says, no, I don't want to sell, but they're not contributing any money. And the other one is paying all the expenses, but wants to sell because they don't want to keep paying all the expenses. So what do? They would have to go to court to get a partition action to either split the property up or force a sale. So when it gets to be, if you think there's going to be cumbersomeness, or you have a lot of beneficiaries, or you want to put some conditions on the sale and situations on, how many votes, by majority vote, then it must be sold. Then I agree with Ian, it could go into a trust for the sale of the house. Houses, along with all the other heirlooms, tend to have people have a lot of emotional reactions to those. So we try to be cautious and mindful in choosing a good plan that's going to work for the beneficiaries as well as for you. Thanks, Ian.
No, thanks, Diane. All right.
Okay, let's see. Can a ladybird deed be done on more than one property you own, home and cabin?
Yeah, you can transfer any property that you have through a ladybird deed. I mean, it depends on the interest in the property you have. But any property that you own yourself. So if you own outright or own in fee simple a cabin and a home, both of those can be transferred through the ladybird deed.
Okay. Next, I see, does a Michigan will suffice within federal probate court? My question is specifically in regards to willing your interest in allotted trust land interest.
So at Michigan Indian Legal Services, we can draft wills that are in compliance with the basically the rules for BIA trust land and IMI accounts and those kind of things. We've worked with Oklahoma Indian Legal Services to educate our attorneys in how to draft those sorts of wills. But if there is specific trust lands in that, there are certain provisions that need to be in the will, and we can draft those at Michigan Indian Legal Services.
Okay. Let's see. I'm a SAG CHIP member, but live in California. Can I still use Michigan Indian Legal Services?
So if you live in California and you own real property out there or domiciled out there, you would need to find a attorney that is licensed in the state of California. Each state has different rules of probate. So different states have different regimes. So the will that you drafted may be valid in another state, but the way that it's probated is different, and we couldn't be the ones to draft that.
Okay.
All right.
That's all the questions I have.
Okay. Well, I'd like to take this time to thank Diane for being here today and providing us with her excellent knowledge base. and taking the time out of her day to be here with us. I'd also like to take the time to thank everyone who listened to this today, and I hope you got something from it. And if you have any questions, feel free to contact us. And lastly, I'd like to thank Norica for putting this on. Norica and Hank.
All right, thank you, Ian, and thank you, Diane. And again, for everyone who's watching, if you could take a few minutes after we post the link to the survey or email it out to fill that out and give us feedback, that would be great. We will be posting a recording on the website in the next few days here and emailing out the information as well. So thanks everyone for joining us. And that will conclude our presentation today.